dealing with the same real estate market. Most people are in this time. And getting offers accepted means really getting a more serious offer on the table from a buyer. And that buyer has only so many, I suppose, tools in their tool belt to create the strongest offer. Earnest Money certainly is one of those. Do you see a lot going on with Earnest Money?
I do. Brokers right now, if you have buyers, you're looking for any edge you can get, any edge, any legal edge. No knocks on the door at 3 a.m., but the bottom line is
your chuckle made it sound like maybe you've done some things.
No, just a humorous pondering of things, but no actual actions outside the law.
Just make sure you keep those in your head. Don't type them anywhere. All of a sudden, they end up in court, and it's, well, did you type this? Yes, I did. It was a joke.
Yeah, I don't think the courts have much of a sense of humor, but fortunately, I do not know. But this information today is really to help first-time buyers understand the ramifications of what they're doing. So earnest money is a really critical thing to know because that is your deposit. Consider them one and the same. Earnest money is a deposit. So your deposit must be submitted at the start of a deal unless you have a written agreement stating otherwise. And there's a number of ways that earnest money is protected, and there's a lot of ramifications to it.
And so, okay, why don't we just start? What exactly is earnest money? Because if you're a first-time home buyer and you've never gone through this, it's certainly something you might be wondering.
Yeah, I mean, earnest money is a negotiable amount. That amount can vary wildly. I mean, if you're buying something small in a rural county, I mean, it might be as small as $500. But generally, in King County, the lowest earnest money you would see would be about $5,000. But quite commonly, for your average purchase price in this county, you'd see an earnest money around $10,000, and then you move up $1 million, $2 million. All of a sudden, you could see 20 up to 50 grand earnest money.
And what does earnest money do?
Earnest money is a sign of commitment to the seller that you, the buyer, you're not just hot air. Even though you've written a contract, almost all written contracts have contingencies, and contingencies are escape clauses geared fully for the buyer and not for the seller. So as a seller, you want to know, hey, how serious is this buyer? So as a buyer, you're showing how serious you are.
You say the escape contingencies. This kind of becomes one of them, I suppose.
Well, the earnest money is a commitment. The contingencies are all escape clauses for a buyer.
Got it. And so, okay, so when somebody actually then puts earnest money down, where does it go? I mean, because they're writing a check. And now, for, as you said, anywhere from $5,000 to $20,000 or whatever it may be, maybe $500, where does that money go?
There's two places it can go. First off, it can be held by escrow. And for buyers who don't know, escrow is the neutral body that help both buyer and seller make sure that both parties get what's coming to them. My analogy has always been that escrow is like Switzerland. They're the neutral party. They're not going to make sure that one party gets more than what's due.
Sure. And more like accountants, really.
Yeah, exactly. And then the other place earnest money can be held is by the selling broker. Now, the state attorneys have used confusing language for a long time, so I should clarify. A listing broker and listing office are who represent a seller. The selling broker and selling office are who represent a buyer. I know the verbiage sounds confusing. Even my friends who are property law attorneys give me the quizzical look like, are you sure you have that right? Yes, that's the way they state it. So the selling broker can hold earnest money as well.
So you're giving the money to the guy or gal who's driving you around in their car, showing you houses. That doesn't seem very scary. Here, hold this.
Well, if you like peace of mind on that, any broker who mishandles earnest money loses their license for 10 years, and I'm sure is prosecuted to the full extent of the law. So, none of us want to be known as someone who mishandled earnest money.
Right. Well, it makes sense. So then what happens to it? I mean, it gets a check. I give you a check, or goes to the escrow or the, Switzerland, as you say. And then does it just sit there? How does it happen? What happens to it over maybe the 30 days?
Escrow has a trust account, and they hold all the earnest money amounts, for all their deals in that account. Now, if you go through with the deal, that earnest money will apply to your total out-of-pocket. So for ease of discussion, let's say a buyer needs $25,000 to complete a home purchase. They've deposited...
Say $25,000 down.
Yeah, we'll say down. We won't talk about closing costs, but $25,000 down payment. a buyer puts up $5,000 earnest money at the start of a deal, escrow will call you near closing and say, hey, you owe us another $20K. So it directly applies if you proceed to closing.
So it's just money that gets applied towards something down the road. So you're just kind of putting it up front as you said at the beginning of as the commitment. But what happens if the house doesn't go the way you want it to? The transaction doesn't go the way you want it to. The inspection, the financing, all the different all the different outs a buyer has.
There's two different paths here. One is you cancel or terminate the agreement based on a proper legal excuse in the contract. The other is you as a buyer don't have proper legal excuse, but you can't close. Now you're in what's called default. And there's a specific clause in the contract governing default. And basically, with that default choice on the purchase and sale agreement, it will say, 1, if you default, it's liquidation of earnest money. 2, seller's election of remedies. Well, no one wants seller's election of remedies. That's, lawsuit, that's bogged down in courts. So earnest money has been created to be considered liquidated damages in the event of default so that there's not a lawsuit. If you as a buyer tie up a property, let's say for a month, you have waived all your contingencies by notice, you have no more escape clauses, and then you fail to close, at that point, you would lose your earnest money.
And so really it's, it goes, I guess they call it hard.
Yeah, absolutely. Absolutely. There's definitely a point where if, let's say you've satisfied your inspection contingency, you've waived your financing contingency by notice, and that's a critical one. The financing contingency does not expire. At the end of the negotiated time period in the contract, if the buyer hasn't waived, the seller can deliver a 3-day notice to waive, or else the seller can terminate.
So then if somebody realizes that they're going to need earnest money to buy a house, and in a competitive market, of course, bigger commitments are better, how does somebody determine if the money they're willing to put down or the earnest money they're willing to put up is sufficient to, I guess, create to get a deal?
Well, part of that, there's a lot of gray area there, what is sufficient. So part of that is, let's say I'm representing a buyer. I'm selling this total amount to the seller and their representative, the listing broker, and saying, hey, this is an amount my buyer wouldn't dare walk away from. So that's probably the most important thing, to say, hey, look, we're committed to this. There's no way my client's going to walk away from $5,000. Now, $5,000 might not be that big a deal in, say, $1 million purchase. Folks with that kind of liquidity, they might not care that much. They might tie up a property for 2 months and say, I don't care about 5. So you're selling $1 million home, you might want to see $20K or more to know that if this buyer defaults, it's going to hurt them because you've been hurt because you couldn't sell your home while this buyer had it tied up.
Mm-hmm. And so really it just kind of depends. On purchase price, on probably market, on area, on...
Completely, yeah.
There's no golden number percentage.
No, there's no golden number. 5 and 10K are pretty common numbers to see, but yeah, it's wide open.
And so, what if somebody decides? Let's say somebody's buying a less expensive home. Maybe they're doing an FHA purchase. They don't need a big down payment, yet they've put up even maybe a bigger earnest money than is necessary.
Yeah, you could see that. Let's say someone's buying a $200,000 condo, 3.5% down. That's $7K. Let's say they've got a credit from the seller to cover their closing costs. So they really only need $7K out of pocket to finish the deal. But let's say they were in a competitive bidding situation. They put up $10,000 earnest money. Well, now they're $2,500 in excess of what is needed to complete the purchase. So at closing, escrow would actually cut a check to that buyer back. Say, hey, this is, you didn't need this extra amount.
Sounds like a good deal. You can get some money. I guess it's your money. You're not really getting anything back. It's kind of like tax returns, right? Everybody files, thinks they got all this money back. Really, they just overpaid. It was theirs in the first place.
Perfect analogy, Ben.
Well, it is a couple days after taxes. You everybody got theirs done.
Extension
or
filed.
Extension.
Yep, exactly.
I hear that.